My name is Katia Pomarandino, and I'm honored to have become a naturalized American citizen. It is my privilege to work as an ESL instructor at the Career and College Readiness Center in Great Falls and be part of the leadership work group in the adult education in Montana with five more incredible teachers: Diana Butte, Cindy Kalispell, Carla MSP, Shannon Billings, and Catherine Missoula. By exploring the workgroup website, you'll be able to closely follow the implementation of our workgroup goals. The main topic of our presentation today is immigration. Americans come from many cultures, but the motto that is emblematic of our dynamic spirit and has attracted masses yearning to breathe free is E pluribus unum, out of many, one. We'll come closer to that ideal by helping immigrants integrate by learning English. It is impossible to dissociate the immigration topic and everything we ESL instructors do to help our ESL students, not only to learn English, but mainly to be comfortably and safely part of the American culture. We are starting our presentation with the topic Immigration Explained. The history of the immigration in the United States is key to understand the whole idea. When a foreign national wishes to immigrate temporarily or permanently to the United States, they must be granted authorization by the Department of Homeland Security by applying for and obtaining a visa. Citizens of 38 countries do not need a visa. The type of visa they must file depends on the specific needs or reasons behind their desire to come to the United States. These are the 38 visa waiver countries. There are two types of visas: non-immigrant visas for travel to the United States on a temporary basis, and the immigrant visas for travel to live permanently in the United States. This slide shows the purpose of travel to the US and the related visa type. The visa application can be based on family, employment, the number of visas established by the government, and other immigrant visas categories. An American citizen can file an immigrant visa petition for a spouse, a son or a daughter, a parent, or a brother or sister. The lawful permanent resident, the one with a green card, can file an immigrant visa petition for a spoused and unmarried son or daughter. The employment-based immigration, the employer can sponsor certain skilled workers who will be hired into permanent jobs. In some cases, some specialized fields, the US law allows prospective immigrants to sponsor themselves. The US law also provides a number of special immigrant categories as well as immigrant investor program. The number of visas each year is limited for some categories and also by country. If the country of qualified applicants exceed the available immigrant visas, there will be a waiting list. In this situation, the available immigrant visas will be issued in the chronological order in which the petitions were filed. Employers and immigration. The Immigration Reform and Control Act of 1996 says employers with 4 or more employees may not discriminate against non-citizens with proper authorization to work. Employers are also responsible for verifying the employees are authorized to work in the United States. Employers should complete an employment eligibility verification form, the Form I-9, for all new hires, regardless of citizenship. Asylees and refugees. A person who requests asylum in the United States is called an asylee. A person who requests protection while still overseas and then is given permission to enter the United States is called a refugee. To apply for refugee status, the person must, in most cases, get in touch with the UN High Commissioner for Refugees. To apply for asylee status, a person who is in the United States and if present unlawfully, has not yet been discovered and placed in removal proceedings can submit what's called an affirmative asylum application, Form I-589, issued by the United States Citizenship and Immigration Service. Both refugees and asylees have the right to remain in the United States indefinitely, at least until conditions in their country returns to normal. The refugees receive a work permit and various forms of government support during their first month in the United States. The asylees can apply for a work permit as soon as their asylum is approved. After a year of their entry, the refugees are expected to apply for U.S. permanent resident status, a green card. The asylees, after a year of receiving approval, they can apply for the green card. Both asylees and refugees, after 4 years approximately, can apply for citizenship. So, what is the difference between temporary protected status, TPS, and asylum? TPS is provided by the US government to select countries in response to circumstances that exist in the entire country. For instance, the situation of Venezuela right now. Asylum takes into consideration individual circumstances. For example, somebody that suffered persecution or fear because of religion or race or different political opinion. Another concept ESL instructors should be aware of is the public charge policy. Public charge is an evaluation of someone's history to show the government that they are generally able to support themselves financially and won't be a public charge relying primarily on the government for financial support. Someone will generally only be reviewed for public charge if they are applying to come to the US on a visa, they are applying to become a permanent resident and get a green card from inside the US, and they are in deportation removable proceedings and must defend themselves against a public charge finding. What is considered a public charge? So how will the government decide if somebody relies on their financial help? If someone is using or have used one of the programs in the past from the government, it could determine that that person is a public charge. However, the government will analyze all of the circumstances. So, example, the public cash assistance programs for income maintenance, supplemental secured income, temporary assistance for needy families, state-based cash assistance, long-term institutional care funded by the government. What is not considered a public charge? The Department of Homeland Security will not consider emergency medical assistance, disaster relief, national school lunch programs, the special supplemental nutrition program for women, infants, and children, the children's health insurance program, subsidized for foster care and adoption, government subsidized student and mortgage loans, energy assistance, food pantries and homeless shelters, and Head Start. Negative factors in the public charge evaluation include, but are not limited to, income below 125% of federal poverty level, diagnosed with health condition that could require extensive care or interfere with ability to work. And I'd like to remind you that on March 13th last year, the treatment and vaccine for COVID were excluded and considered not a public charge determination. Having less than a high school degree or equivalent, and not proficient in English. There are some individuals with certain immigration status who are not subject of public charge. For instance, refugees, asylees, certain T and U non-immigrant visas applicants, referred to human trafficking, certain self-petitioners under the Violence Against Women Act. The next two segments of our presentation today are Cultural Shock and Cultural Adjustment by Diana and Catherine, and Immigration Resources for ESL Teachers by Cindy, Shannon, and Carla. The next two segments of our presentation today are Cultural Shock and Cultural Adjustment by Diana and Catherine, and Immigration Resource for ESL Teachers by Cindy, Shannon, and Carla.